At 9:12 a.m., I opened a certified letter that said, "Remove all solar panels within 10 days or face $100 per day in fines." I looked up at the roof, where 18 black panels were quietly paying my electric bill, and I actually laughed. Because in my state, the sun has rights, and I had an attorney named Sonny ready to file a forecast the HOA wouldn't like. I didn't put panels up on a whim. We planned for months. We met with 3 installers, picked low-profile black-on-black modules, and submitted a proper architectural review committee application. Layout, materials, roof load calcs, even a rendering from the street. The management company emailed, "Received, ARC meets next Tuesday." Next Tuesday came. Then another. Silence. Meanwhile, my utility offered a rebate that would expire in 4 weeks. The installer said, "We can schedule you now pending HOA approval. Worst case, they ask for a conduit color change." Reasonable. We waited. We followed up, heard nothing. Week 5, the installer called. "Panels are ready. Do you want to lose the rebate?" I emailed the HOA again. No reply, so we scheduled. One bright Friday, the crew showed up, masked off the roof, and by sunset, 18 sleek panels were lined up on the south face, visible from the street but flush with the shingles. The conduit was painted to match. It looked good and right. On cue, the HOA found its voice. Monday morning, the certified letter arrived. Unapproved exterior modification. Remove within 10 days. Additional penalties may apply. ARC's decision, denied. Denied? When did they even meet? I called the management office. A woman named Carla answered in what I can only describe as beige tone. "Yes, Mr. Walker, solar panels are not in harmony with the architectural design standards." I took a breath. "Carla, I filed 5 weeks ago. When did the ARC decide?" "Last Thursday," she said. "Your application was not complete. It had 3 attachments. They were not visible to the board," she said. "Also, there have been complaints about glare." "My panels are anti-reflective," I said. "Less glare than a window." "Nevertheless," she said, triumphantly inserting a word she'd been saving. I hung up and opened my laptop. If nevertheless had a natural predator, it was state law. In mine, HOAs cannot prohibit solar energy devices. They can impose reasonable restrictions that don't significantly increase cost or decrease efficiency. If you're wondering, many states have similar laws. California Civil Code 714, Texas 202, GATSO 10, Florida 163.04, check yours. I printed the statute, highlighted like it was a final exam, and reached out to an attorney recommended by my installer. Her name, because the universe has a sense of humor, was Sonny Delgado. Sonny listened, then said, "This is basic. They can't ban or force relocation that kills production. We'll ask nicely once. Then we'll let the photons speak." Sonny sent a friendly letter to the management company. Our client submitted a complete application. Under state solar access law, any restriction must be reasonable and cannot materially increase cost or reduce efficiency. The installed system meets all building and fire codes. Please rescind the violation. The board responded with a bald refusal and a list of creative concerns. Aesthetic disharmony, potential glare hazard to drivers, fear of reduced property values. We prefer panels on rear roofs only. Sonny called me. "They're swinging in the dark. We'll get light on it." Literally. We hired an independent energy consultant to do a glare and production analysis. He used PV watts to model 2 layouts, front roof, our current, versus rear roof, what the HOA wanted. The rear roof faced east-northeast and was shaded by a beautiful, stubborn oak. The model showed a 24% annual production drop if we moved them. The glare simulation showed less reflectivity than our neighbor's second-floor windows. Meanwhile, the neighborhood's very own Karen, Diane from the HOA board, started a campaign. She posted in the community Facebook group, "Panels belong on the back. We don't want this to look like an industrial park. Who's with me?" Half the replies agreed. Half posted their summer electric bills and a string of crying, laughing emojis. Jerry, my next-door neighbor with an old pickup that ran on hope, stopped by. "Heard you're beefing with the sun," he said. "Apparently the sun started it," I said. "Attacked the neighborhood with photons." Jerry nodded gravely. Classic sun behavior. The HOA scheduled a violation hearing. Sonny told me to keep it calm and all business, so I wore my nicest "I pay taxes" shirt and brought a binder that could have survived a tornado. Application timestamps, emails, the statute, the consultant's report, and photographs of similar panels in our own subdivision. The board sat at a folding table in the clubhouse like judges of a very small talent show. Diane wore her tan visor indoors and had a laser pointer, which is how you know someone is ready to dazzle you with PowerPoint. She started. "We have standards. Black rectangles on the front of homes are not consistent with community aesthetics. Also, glare might cause accidents. Also, some buyers don't like panels." She clicked, and a slide appeared. "Potential glare hazards. Source, Pinterest." I wish I were kidding. Sonny went next. She didn't raise her voice. She didn't even stand. "The state solar access law preempts any covenant that effectively prohibits solar energy. Restrictions must be reasonable. Forcing relocation to a shaded off-azimuth roof is unreasonable. It reduces production by 24%, which is material. Here's an expert report." She slid the binder forward. "Also, these modules are anti-reflective tempered glass. The FAA uses more reflective surfaces on runways." Diane frowned. "We don't want to see them," Sonny smiled. "That's not the legal standard." Then Diane tried a twist. "You installed without approval." I pulled out printed emails. "We submitted, followed up twice, and never received a response. The ARC met after the installation and denied it retroactively. That's not a process problem on our end." A board member named Rick leaned forward. "What if we let you keep them but require a decorative false dormer to hide them?" Sonny glanced at me. I shook my head. She said, "A false dormer would shade the array and add thousands in cost. That's not reasonable." They went into executive session. We waited in the hallway while a vending machine hummed like it had legal opinions. When they called us back in, Diane delivered the verdict. "The board is upholding the violation. Move the panels to the rear roof within 30 days. Fines will begin on day 31. Sonny stood. "Okay," she said lightly. "We'll let the sun sue you." No, the Sun didn't sign a complaint with a little smiley face, but Sonny's lawsuit might as well have been titled Photons v. Pout. We filed for an injunction, stopped the HOA from fining me while the court decided whether their restriction was lawful. The complaint quoted chapter and verse of the statute. It cited the 24% production loss and the anti-reflective glass specs. It even included a photo of the industrial look the HOA feared, side by side with a photo from a Tesla ad that made my roof look like a magazine cover. Then the story grew legs. My installer's PR person pitched a local reporter on Homeowner battles HOA over solar rights. Channel 8 called. I remembered them from Chalk Day. "Can we film a quick stand-up on your street?" the reporter asked. I told Sonny. She raised an eyebrow. "Media?" she said. "Humanity loves a sun versus clipboard story," I said. She sighed. "Don't say anything like, 'The HOA are idiots.' Say, 'We appreciate the board's service and we're asking for compliance with state law.'" The segment aired that night. The B-roll made my panels gleam. A sustainability researcher from the local university said, "Modern panels reflect less than a window. The aesthetic argument is outdated." The HOA declined to comment, which is media speak for "the comments section will roast you." The next morning, 3 neighbors texted me, "How much did you save on your bill?" One asked for my installer's number. Jerry sent a picture of his electric meter and wrote, "Mine spins like a fidget spinner in July. Help." Before our injunction hearing, the HOA's attorney reached out. "Would your client consider mediation?" Sonny asked me. I would. "Consider the board reading the statute out loud together like a book club," I said. "But sure, mediation." We met at a neutral law office that smelled like old carpets and new money. A retired judge sat between us. The HOA opened with a new line. "What about adding trees to the front yard to improve aesthetics?" Sonny didn't blink. "Trees that shade the panels would violate the same law. We'll happily plant on the sides." Diane tried one last throw. "If we let you keep them, everyone will want them." Sonny smiled. "That's called progress." We settled on terms that read like a weather report after a storm. Panels stay exactly where they are. All fines rescinded. No daily penalties. HOA, to adopt solar guidelines consistent with state law, low profile, neutral frame color, concealed conduit when feasible, but no bans or unreasonable relocation. My reasonable attorney's fees covered. Sonny's smile turned approximately solar. After we signed, Sonny turned to me. "Do you really want to poke the bear?" she asked. "Maybe just a gentle poke," I said. So I organized a sundae on my driveway. We set out lemonade and mason jars and a poster board. How much did the sun pay my bill? I wrote our July total, $24.13. People took pictures. The Channel 8 reporter dropped by for 10 minutes and got her B-roll of kids drawing suns with chalk on my sidewalk. Deja vu with a brighter theme. Within a month, 3 more homes on our street installed panels. The HOA adopted a clean, one-page guideline that read like an adult wrote it. The Facebook drama cooled. Diane kept her visor but lost the laser pointer. Then something quietly beautiful happened. A neighbor 2 doors down, a single mom named Priya, asked me, "Does solar help in winter?" I explained the production curves, the net metering credit, and the fact that our system had microinverters that shaded modules. "Don't drag down the whole array." She went inside, came back out, and said, "If I can get my bill under 100, I can enroll my son in the robotics club." She signed her contract the next week. Here's what I learned while the son and my HOA traded emails. Know your state's solar rights. Most states protect homeowners from HOA bans. The test is usually reasonable restrictions that don't materially increase cost or decrease efficiency. Relocating to a shaded or wrong azimuth roof is almost always material. Paper beats. Passion. Show your math. Production models, PV watts, anti-glare specs, building code compliance, these turn opinions into data. Don't escalate alone. A calm lawyer's letter and an independent expert do more than 1,000 Facebook posts. Offer compromise that isn't surrender. Conduit painted to match? Yes. Hidden wire runs where feasible? Yes. Moving to the back roof to satisfy a vibe? Don't shine a light, politely. Media, neighbors, and the city's sustainability office are sunshine. Most bullies squint in it. And one more thing, if you're fighting for clean energy, be the kind of neighbor people are happy to copy. Share your bill. Bring the lemonade. Invite the skeptics to stand in your driveway and feel the quiet hum of something that pays for itself every sunny day. If you like stories where HOAs try to shade progress and get burned by the law instead, hit subscribe, drop a like, and tell me your wildest HOA versus solar moment in the comments. Until next time, may your panels face south and your neighbors face facts.